Hello again, everyone. Welcome to Washington Gun Law TV. I am Washington Gun Law President William Kirk. Thanks for joining us. Well, this has been a terrible couple of weeks. Mass shootings in Buffalo, New York, Tulsa, Oklahoma, Chattanooga, Tennessee, and of course the one that has gripped most of our country's attention, the terrible and unspeakable tragedy in Uvalde, Texas. Now, of course, this has people on both sides of the political spectrum screaming bloody murder about either we need to take guns from everybody or the solution to our problem, of course, is more guns. I'm not going to engage in that debate, but one of the things that does happen when these tragedies occur is legislation is kicked around, and there is numerous pieces of federal legislation being kicked around right now. I want to talk to you about one that we're familiar with here in Washington, one that I think has a high likelihood of becoming federal legislation. So let's talk about what would a federal red flag law look like. Okay, so the issue we're going to be talking about today is red flag laws. Now, after all of these horrible and unspeakable tragedies, we have all sorts of gun control legislation being kicked around, from AR bans, magazine bans, federal firearm licensing requirements. The list is really only limited by some person on the left's imagination. Now, what's likely to occur is that we're going to see some very radical pieces of gun legislation passed out of the House of Representatives. Why? Well, that's what your House of Reps do. That's where all the crazies sit. However, the likelihood that any of that more radical or restrictive gun legislation is going to make it out of the United States Senate is pretty remote. So I'm not going to waste a lot of time talking about some of the ideas of Sheila Jackson Lee and others such as that. But I do want to talk to you about a piece of legislation that I do think has a pretty significant chance of becoming part of federal law. And it's one that some of you are familiar. In 19 states, we do have red flag laws, but in the rest of the country, we do not. So this video is going to kind of help you familiarize yourself with what red flag laws are. And why do I think that Washington serves as a good model? Well, we've done a video before about why everyone should pay attention to Washington gun laws. And one of the big reasons is that when you take a look at what we do here in Washington State, you can find similar legislation, almost verbatim similar legislation, usually being proposed on the federal level about 12 to 24 months down the road. Now, we've had red flag laws here in Washington State for several years now. We have a more euphemistic term for it. We don't call it a red flag hearing. We call it an extreme risk protection order hearing, or what we call an ERPO. The legislative scheme is found in RCW 7.94, and I'm going to walk you through it and give you some bullet points today so you can understand how does this legislation work. Now, having had an opportunity to represent dozens of people on ERPO hearings, while I can say that I do believe that the intent of the legislation may have had some good parts to it, the manner in which the legislation was passed, and more importantly, the procedural mechanisms that are in place, provide a litany of what I believe to be constitutional problems for you, the lawful and responsible gun owner. Okay, so let's get you up to speed on how this law works. Couple terminologies you need to be aware of. Petitioner. Petitioner is the person who is asking for the order to be issued. Respondent. That's the person who's answering to that complaint, the person who the order would be issued against. Under RCW 7.94.030, an ERPO can only be brought by either a household or family member or a law enforcement agency. If you are not a family or household member or a law enforcement agency, you do not have standing under Washington law to bring an extreme risk protection order. Now, there certainly are other ways in which other people outside of the family unit can attempt to take a person's firearm rights away through anti-harassment, protection order hearings, and such like that. But when it comes to extreme risk protection orders or red flags, it will either be a law enforcement agency or a family or household member that will be the petitioner. The petition has to be filed in the county in which the respondent resides, and the petition has to state the following under the statute. A petition must, A. Allege that the respondent poses a significant danger of causing physical injury to self or others by having in his or her custody or control, purchasing, possessing, accessing, or receiving a firearm, and be accompanied by an affidavit made under oath stating that the specific statements, actions, or facts give rise to a reasonable fear of future dangerous acts by the respondent. So what the petition has to state is that you, the respondent, poses a reasonable fear to yourself or others by having access or possession of firearms. The petition must also identify the number of firearms, types, makes, and models that the respondent would have access to. If the petitioner does not know how many firearms or the makes and models, if the firearms were purchased as a Washington State resident, the Department of Licensing would have records of each and every model that was purchased by that respondent. If law enforcement is the petitioner, they have a statutory duty to notify any family or household member of the pending petition. Now, one of the biggest concerns from a constitutional standpoint, and used often by those who oppose red flag laws, is what Washington State did in RCW 7.94.050. Because when a petitioner goes to a court to petition for a red flag order, they are given a temporary hearing, which is conducted ex parte. That means that the petitioner and the petitioner only gets to communicate with the judge to see if the judge will issue a temporary order. The statute specifically reads, a petitioner may request that an ex parte extreme risk protection order be issued before a hearing for an extreme risk protection order without notice to the respondent by including in the petition detailed allegations based on personal knowledge that the respondent poses a significant danger of causing personal injury to self or others by having in his or her custody or control, purchasing, possessing, or receiving a firearm. So yes, that's right. Someone can write up a bunch of allegations on paper, claim that they have personal knowledge, take it to court. If the judge believes that that is grounds for a temporary ex parte ERPO order, then yes, you will be ordered to forfeit your firearms without even having a day in court. In fact, under Washington law, the hearing for the temporary order has to be conducted within 24 hours of the petitioner filing it. So yes, that means that a lawful and responsible gun owner could receive a court order or a bunch of law enforcement arriving at your door saying, we have an order for you to surrender all your firearms, and they could in fact take possession of each and every one of your firearms and your concealed pistol license without you having yet had your day in court. Now, when it comes to the procedures and how these permanent order hearings are handled, there are several concerns that you as a lawful and responsible gun owner should have. The first one, of course, being that this is a civil hearing, which means that the burden of proof is not proof beyond a reasonable doubt. No, you see, the burden of proof is actually preponderance of evidence. We just have to slightly tip the scale to the petitioner's favor. In addition to that, the statute here in Washington, 7.94.040, lists out a litany of criteria by which the court is to consider when determining whether or not to issue an order. Now, some of these criteria are very obvious criteria: acts of violence, violations of previous no-contact orders, current allegations of domestic violence, things such as that. But some of the other criteria that the court can use is simple things such as acts of anger in the past, the common use or display of firearms, the ability to easily access firearms, things that most lawful and responsible gun owners almost engage on a weekly basis in. The other big concern, and this is a huge concern, and it should be for everybody around the country, is how is the evidence presented? Is the petitioner required to take the witness stand, swear in under oath, and then be subject to cross-examination? Well, some jurisdictions in this state will actually do it that way, but most jurisdictions, especially those in the larger, more populated counties where the court system is already congested, no, they instead will conduct this hearing through declarations and affidavits. The law specifically states the court may, A, examine under oath the petitioner, the respondent, and any witness they may produce, or, in lieu of examination, consider sworn affidavits of the petitioner, the respondent, and any witnesses they may produce. So yes, that means that the court can forego live testimony and preclude respondent's counsel from having an opportunity to cross-examine the petitioner about the allegations. And having been a trial lawyer now for 22 years, if we do this through declarations and affidavits, it is very difficult to cross-examine a piece of paper. Oftentimes, this is left with respondents having to write their own declarations in which they're basically saying everything that the petitioner said is BS. So yes, is it possible under a red flag law that an otherwise lawful and responsible gun owner could have their Second Amendment rights stripped of them by false allegations reduced to writing with no ability to cross-examine? The answer to that question is yes, and I have seen that happen. In fact, one of the places we most often see this is in the ongoing and incredibly tenacious and adversarial divorce proceedings, where one spouse, now very angry at the other spouse, starts making all sorts of allegations to have their firearm collection stripped of them. Now, under Washington law, if an extreme risk protection order is granted, it shall last for 1 year. At the conclusion of that 1 year, the petitioner may ask for the order to be extended, and the same criteria that we talked about before is used to determine whether or not the order be extended. Let us not forget that one of the criteria that the court could use is there an existence of an extreme risk protection order, which means that the existence of one could, in fact, in the eyes of some courts, justify the extension of one without any further factual allegations. Now, when and if the extreme risk protection order is finally canceled, does the respondent get their firearms back? Under Washington law, specifically 7.94.100, the answer is yes. The law reads, if an extreme risk protection order is terminated or expires without renewal, a law enforcement agency holding any firearm that has been surrendered pursuant to this chapter shall return any surrendered firearms requested by the respondent only after confirming through a background check that they are currently eligible to own or possess firearms under state or federal law. So yes, you would eventually get your firearms back. The point I'm trying to make here is this, is that while I think there is a lot of crazy legislation that is being kicked around that has zero chance of passing and even a less chance of actually making a difference, I do believe that there is a high probability that a federal red flag law could be passed into legislation, thus mandating every state implement their own red flag laws. I do believe that Washington State, unfortunately, will serve as a model for what a red flag law should look like, and it is with high probability that you may see similar laws coming to your jurisdictions. Listen, if you have more questions about red flag laws, how they work in Washington, or anything else related to your Second Amendment rights, don't ever hesitate to contact us at WashingtonGunLaw.com, or of course you can call us directly at 425-765-0487. Now, let's remember, part of being the lawful and responsible gun owner, like we talk about all the time here at Washington Gun Law, is to know what the law is in every situation and how it applies to you in any instance that you may find yourself. Until next time, thanks for watching, and stay safe.